and welcome back to another live webinar with the Private Practice Growth Club. Last week, we hosted Ilana Stein from the company partners, and we spoke all about how to register your private practice business and the difference between having an Inc. and a sole prop and various compliance issues. If you haven't seen that, you can scroll down in the feed. It should be there. And I haven't put it on YouTube yet, but I will soon. So do subscribe to youtube.com/Private Practice Growth Club if you want these kinds of information and tutorials and tips about starting and growing a private practice. So today we're going to continue with the conversation with Ilana. She's graciously given up of her time for now 2 weeks in a row. And today she's going to be talking to us a little bit more about what the compliance issues and around what entails around the Memorandum of Incorporation and various other things. But I will bring her up and she can explain all that to you guys. So welcome, Ilana, and thank you so much for joining us again.
Thanks, Tasneem. It's absolutely wonderful to be back again. And yeah, I'm looking forward to a great afternoon with you guys.
So tell us what you are going to be discussing. Would you like me to bring up the presentation now and get straight into it?
That's fine. I can maybe just give you a quick breakdown of what we're discussing this afternoon. So obviously on the previous session, we had a bit of a discussion about sole proprietors, incorporated companies, and what do you do if you've got a PTY limited. So today we're just taking that a bit further, and I think some of the questions that came up was, what do I do if I need to change the name, or if I've got a PTY limited and I had to convert that to an Inc., and also if there's a change of directors or shareholders. So we're going to look a little bit into that today. So I want to just touch base on that. And then I think an interesting thing that came up was also partnerships. So I think we're going to start today a little bit on that, but then we'll take that over because I would love to get a tax specialist in on that as well. And also looking at contracts. So usually that's where the liabilities and things come in. But with that, we can jump into this afternoon session.
Okay, great.
Excellent. So today is actually part 2 of our session. So once again, thank you, Tasneem. Just a quick rundown of what we discussed the previous time was about the difference between a private company and non-profit. And then as you can see, the little Tabu is joining us today as well, representing the incorporated companies. So those are the companies that's for the professionals, being the attorneys, the doctors, the engineers, and it's usually where there's a specific liability involved in the company as well. So going further from that, we spoke about naming the practice. So as you remembered, we did a bit of research, and it was specifically to say that there needs to be the name of the owner needs to be included in there. Retain the name if you want to retain one of the past practitioners. Obviously, you have to get the consent from them, and then also not using the words hospital, clinic, or institute. So, Tasneem, I remember you having some difficulties getting your name registered. So I actually sent that through to them. Unfortunately, I haven't had the opportunity to get the feedback yet. So I think you've definitely thrown them a curveball, but hopefully on our next slides, we will have some feedback on what happens if all the options of your name are already taken. So as you can see,
well, I haven't actually checked because I haven't tried to register my own name, but I know my name is very common, and that is a legitimate thing to wonder about if we are so limited in what we want to name our practices.
So that's great. We hope that Desmond would definitely be able to help us there and just give us some guidance. But as you see, he's graciously sent us some examples of what you can do. That's being Desmond and his surname incorporated, or just his surname. And there's some of the examples that you guys can then use when deciding on the name of your practice. And then also that is the link of the draft document that he sends through to me in terms of the rules of naming your practice. You're also welcome to send me an email and I can forward that on to you guys as well. So taking a look at the personal liability, just a quick rundown of what we've discussed last time is to say that you have to have an MOI specifically the 15.1B if it's a personal liability company. Once again, if you've registered the company under the short format, maybe a Pty Limited, it can be converted. What we will then basically do is use a special resolution with CIPC. We will then attach the new MOI and register it that way, which means you will also have no par value shares. And maybe, Tasneem, that might be something that we can touch on a little bit later as well. So the special resolution, just to let you know, needs to be approved by all the shareholders as well. And then you need to clearly indicate the authorized shares in the company as well as the number of the directors. So when we do that conversion, that needs to be very clear to CIPC what is happening there. Then you can see Little Tabu asked the question about ring fence. I don't know, Tasneem, have you ever heard the concept ring fencing?
Yes, I usually see it pop up when you do your tax returns, and they've got something around ring fence, but I don't know what that is. I don't understand it.
No, that's perfect. I thought I'll actually just bring it in here for you guys, especially because we're going to talk about partnerships today as well. So what ring fencing means is that there is a specific clause or requirement for that company to exist. So say, for instance, you go into a registration of a company and you get a supplier that will then only supply you with a specific product if you are registered with them. And for that purpose, you are like a restriction on the type of company and what you can sell. So say, for instance, I usually take the example of maybe a BMW. So you want to open up a dealership somewhere and you want to be a representative of BMW Tiger Valley and you want to sell the cars, and they will only allow you to register your company with that name if you sell genuine BMWs or the parts. And similar to what you guys might experience in your industry. So if there is a requirement by an organization or a company you get involved in to say that you are only allowed to use their products, and if you're not going to use that anymore, you will then have to dissolve the company, then the abbreviation RF will then be added to your company as a ring fencing. So if ever you see a company that's got the abbreviation RF at the end, you must ask them, what is the purpose or what is that ring fencing? How are they being, it's like they're being boxed in to say that you're only allowed to do a certain thing or sell a certain product.
Okay, I see. So it's kind of like a limitation on what you're allowed to trade in or service.
Correct, yes. And that's specifically also if you look at partnerships. So there might be a restriction to say, I will only get in partnership with you if X, Y, and Z happens. And you can actually bring that in as part of your MOI or restrictions so that you make sure that somebody else do not follow through on maybe not adhering to those regulations. Then, interesting enough, we also said that if you were registered before May 2011, you can always convert your memorandum of association to the new format MOI. So then what we will basically do is once again do that special resolution. So those of you that's registered the companies way before May 2011 will still remember par value shares. So we'll touch a little bit about the shares today. And just once again indicating the authorized shares in the company and also the number of directors that needs to be clearly stated. So moving on from there, just again, a personal liability is a juristic person by itself, and the previous shareholders agreement takes preference under the Old Companies Act. But now the MOI takes the preference. So what used to happen, Tasneem, was that the companies would be registered and then they will have a separate shareholders agreement to say how things must happen. So under the New Companies Act, they said that it's not going to work like that anymore. You need to take the specifications of that shareholders agreement and actually incorporate it as part of your MOI if you want that to take preference. So that's just something that you guys need to know, especially if you're still under the Old Companies Act and you're going to do that conversion. So as we mentioned to you guys before, also the specific section in that MOI that needs to stipulate that the directors and the past directors are jointly and severally liable. Once again, it's taking responsibility with the company for whatever happens in that company for the period that you are actually appointed as the director of the company. And as I mentioned to you, I always include the little sections of the Companies Act. So if you wanted to go and do that light reading tonight, you're more than welcome to do that as well. So the custom MOI ensures that the provision that governs the relationship, the responsibilities, the risk involved, and also the accountability of the directors. Sorry, let me just move on to the next one. So I thought it would be interesting to maybe tell you a little bit about what rules can be incorporated in a company. So this might be things like the authority of the directors and shareholders, what they can and cannot do. It can also be the nature and the frequency of meetings. How regularly do you need to get together? If there's any specific notices that needs to happen. It can also include things like financial strategy. So that can be anything around debt, dividends, maybe capital acquisitioning or fundamental transactions. So you can actually stipulate that as part of your MOI as well. Interesting enough, you can also put your
Yeah, that is something that I wondered about as well, because I've only ever just been in business by myself, and like you kind of just like I'll just see this new software tool and think, oh, okay, I'm going to buy that. But now obviously you can't just do that if you are more than one director in the company, or like in a private practice. If you decide, are you going to buy a certain assessment tool that costs like 10,000 rand, then you have to obviously have some way of agreeing on that together, and how much is each one going to put by, that kind of thing.
Exactly, and it could be, especially if you are passionate about using technology. I mean, we all know that can really skyrocket if you look at what there is and how you do that. And I think that's where the financial strategy will come in to say, how do we curb the spending, or how do we make decisions around these things, or will it be one 10,000 rand goes to you and the next 10,000 rand goes to the next director? How do we decide these things? And I think a lot of times we don't think about it up front. And then when it comes to, but I need this and I need that, then that's where the scuffing starts. But in any case.
And is that also where you would outline? So I think most people don't think of this until, like you're saying, the operational side of running the practice comes in. But I'm just thinking, like in terms of when I used to live in a complex and we were part of the body corporate, and then we decided not to use a managing agent and handle the complex accounts ourselves. So it's kind of like that. We had a memorandum of understanding of incorporation and all of this stuff. And then we had to have some system in place with one person must load the payments and the other one must release the payments. Is that also the kind of thing that you need to set up? Because say there's three of you, who's going to pay the electricity, who's going to pay the rent? How do we monitor what is coming in and going out of the account?
Obviously. So I would say do not go into too much detail. Like, I mean, you don't want to change the MOI the whole time if you decide to make some changes to the company or to the decisions being made. But maybe stipulating that certain expenses, I think we touched on this the previous time as well, to say anything above 10,000 rand needs the approval of 2 or 3 directors, or just get away that you say, listen here, small things we're not going to get into each other's hairs, but if it might affect maybe how the capital is being distributed, or how we're going to spend 50,000 rand of the organization's money, or whatever it might be, just kind of think of what is the situation, and where would you like somebody else to be like a co-partner for you in that, to say where's the limitation on how you're going to spend the money. And that brings me to the next point as well, is the marketing strategy. Because we all know that marketing is quite important to put it out there. But if you have to make the decision between buying a new machine or equipment versus marketing yourself, that can be quite tricky because you need the client, so you need to market, but on the other hand, you need to get the right equipment in place as well. So it's good to maybe have some guidelines in terms of how you would proportionate something like that. Maybe saying 10% of our turnover we would put towards marketing, but we will not exceed 15%. That's going to be up to you guys deciding something like that. Once again, I won't go into too much detail on your MRI because should you want to change that, you don't want to change the MRI the whole time, but maybe the basic principles would be good. And then the same with the business model. How are you going to run this company? Are you only going to do certain services, or do you want to make it open? And once again, you can stipulate it there. And then also a succession plan for the directors. What happens if you no longer can operate in your facility, or do what you're supposed to do, or maybe something happens and you're in an accident and for 6 months you can't work, or maybe forever you don't know what the situation must be. So is there a succession plan should one of the directors not be able to continue? And it's small things like that.
I'm so glad you brought that one up because I've been trying to find somebody who can specifically do a webinar on succession planning. But most of them are people who are dealing with big companies. But it's such an important thing because, I mean, my specific question was like, even if you're a sole prop and if you're the only one working in your practice, I know it's a morbid thing to think about, but I always think about these things like, what happens if I fall off the end of the earth tomorrow, and then like my clients that are waiting for their projects to be finished or whatever. So in the case of private practice, like at least in a company, there needs to be also, if you take into account all these rules that we have around data protection and things like that, if you haven't stipulated who's going to kind of wrap up and what's going to happen to your clients in the event that something suddenly happens to you, then what? Are those clients' documents all lost? What happens with it? Those are things that people need to think about, which we don't tend to want to think about, but it's quite important.
I absolutely agree. And you know what? I actually did a business coaching course this year. And some of the concepts that's in there really opened my eyes about how we think about business and what happens. And especially like in COVID as well. What happens if you do get affected by it, or your business have to close down and you've got certain commitments to other clients? What happens then? So I think succession planning would be a very good topic for you guys as well.
Yeah.
So maybe running on from there is just the compliance requirements for incorporated companies. So once again, we touch base, and you can remember that hardcover book I showed you last time. But the basic requirements for a personal liability company is basically having one shareholder and a minimum of one director. So you can always have more. And what I try to explain to my clients is, do not have too many directors on your board of directors, because remember, each time you go to the bank or you need to make a decision or anything like that, you have to get their approval as well. Once again, in your case, it might be slightly different because you are all liable for whatever happens in that organization. But it's a general practice to have at least the one director or the one shareholder in the organization. You have to have the MOI, and you need to obtain or retain the company records. So as I mentioned to you before, you need to see the date on which the director was appointed and when he resigned, because that's important in terms of the liability for when the decisions are being made and the information that was given through. You also have to have your accounting records and then annual financial statements. You might be required for the to compile an independent review by an accountant, or you will see at the bottom I've actually indicated an audit. So depending on that public interest score that we spoke about last time, you might need to compile financial statements to be audited by an auditor as well. You need to have a registered address. So a registered address is the address that they will use to some or send legal documents to. So if there's maybe a summons or something that needs to be delivered to you, they use that registered address. So what happened in the past, a lot of times clients will register companies and they will use the address details of the auditors. So then maybe a summons get issued and that goes to the auditors, or and then you don't receive it and there's a specific deadline to it. So there was a court case and they actually decided that the registered address of the company should be the address where you are practicing from or have your main company situated at. So those of you that still got your registered offices at your auditors or your tax practitioner or anything like that, please change that because it's supposed to be an address that's linked to your business directly. Then we also spoke about annual returns. So annual returns is the yearly fee that you need to submit with CIPC to keep your company active. So it doesn't have anything to do with your tax returns. It's actually with CIPC directly that you need to submit to say, hi, I'm still here, I'm still operating. So it's just a way of them keeping track of active companies as well. And then also a director's report that can be compiled. So just moving on from there, I've touched base a little bit about directors and shareholders. So I just want to give you some information today. So you've got South African directors. There we use the identity documents. And then non-South Africans, we usually use the passport. And then actually, interesting enough, is who can become a director. There's a minimum age of 18. So there are some requirements on that. So you can have people appointed that's younger than 18 years old. So maybe 17 or whatever. I think you still need to get your qualification though. But overall,
Yeah.
you can get the consent from the parents to actually say that that person that's younger are appointed as a director of a company. So just for interest sake, I thought I'll put that in there for you guys as well. And then once again, the MOI determines the extent and the responsibilities or duties. It can also stipulate if there's educated directors required on the company, so a certain level of qualification, and also for the approval of the required distribution, the financial assistance, or the issue of shares that needs to be stipulated in the MOI. So you will see there I've put the question mark on the banks. So interesting enough, there are certain banks that would put a restriction on the opening of the bank account if there's foreigners appointed to the company. So just make sure that if you do get stuck on a point like that, is maybe get the company registered with a South African director first so that you can get your operations up and running. And then you can always add the director at a later stage. And then you can just obviously inform the banks of that as well.
So also then with the directors, and when it comes specifically to health professional and private practice, my understanding is that as an occupational therapist, that would be another added stipulation, is that only occupational therapists can be directors in the occupational therapy practice.
Correct.
Is that correct? Yeah.
Yeah. So a little bit later on, I will touch on partnerships. So that's where you could probably have a partnership with somebody that's in a different field or maybe in a different setup where you can partner up with them, but they don't necessarily have to be a shareholder or a director of your organization. And I think that might be something that you guys can look at as well. So just touching base on the director as well, just to say, when can you serve as a director of a company? So you need to be elected to be appointed. So somebody needs to say, we elect you to become a director of the company. And you as a director have to sign a document to say, I accept my appointment. Because otherwise I can just put your name down on any of my companies and you won't even know about that. And then it's also important to know that the person is not disqualified. So I'm going to touch base on the qualifications a little bit later, but there are certain restrictions where CIPC will say this person is not qualified to become a director of a company, and you need to be aware of that. So there are ways that you can appoint new directors to a company or resign them. With CIPC, it's called the form COR 39. And there we can change the surnames of the directors. So say, for instance, you get married and you take a new surname, we can change that and we can update that for you. You can appoint new directors, you can resign directors, and you can even remove directors. So the concept of removing directors are quite interesting. So then we usually look at somebody that are not fulfilling their role. And that once again brings us back to that MOI, is what was the responsibility of the director? So if you maybe stipulated in your MOI that you need to attend at least all the meetings or at least 3/4 of the meetings or whatever, and that person doesn't adhere to the rules and the regulations, and they just absolutely don't care about the meetings, they never show up, they're not part of the decision making, according to that section 71 in the Companies Act, if they did not adhere to their requirements as a director, you can actually submit a request to CIPC to have that person removed. With that application, you will obviously have to give the necessary proof to say, this is how we tried to contact the person, or this is where we requested them to attend the meetings, or whatever it might be. And then CIPC will look at that and see, does that correspond with what the MOI requires? But it actually does happen, and there is that regulations that one can follow to remove a director if they don't partake in what's supposed to happen. And then you can also change the address of the director. So remember, if you move, your details are actually captured on CIPC. So say, for instance, I'm moving from Cape Town to Joburg, and now somebody needs to get hold of me or send me this document to say that I'm not involved in the company and they now want to remove me as a director. They will use the details that's actually stipulated on CIPC, which means that if I moved and I didn't update my details, I will never receive the documents. So it's important to, whenever you change your surname or change your address or anything like that, just to update that with CIPC to keep it relevant as well. And then at the bottom, I've included also the details of other types of directors. So not necessarily on the incorporated companies, but you get something that's called an alternate director. So that is in the case that if somebody cannot attend a specific meeting, they could have appointed an alternate director to their title as a director to say that if I'm traveling, that would be wonderful, 9 months out of the country, I can appoint Tasneem to be my alternate director for board meetings. So that might be something maybe in a bigger group where somebody's really traveling a lot, then that alternate director is appointed for that person only, and they basically take on the role of the director when decisions are being made.
So it's kind of like a proxy.
Exactly. So proxies are used in certain instances, but an alternate director is actually somebody that is appointed on CIPC's records as the official person to stand in for you.
Okay.
Then you get executive and non-executive directors as well, and then also prescribed officers. So prescribed officers would be somebody like, maybe it's a big organization and you want a dedicated company secretary or a public officer that's then going to attend to your SARS documents or anything like that. So there are certain roles that you can actually officially appoint with CIPC as well. And then the last little section that I've put in there was the King 4. So that is your corporate governance. That's kind of like the rules and the regulations on how to be a good director or how to be a good shareholder in a company. And I'm just going to touch base on that quickly. So how must you act as a director? You need to act in good faith, for the proper purpose, and in the company's best interest, not your best interest as the director, but in the company's best interest when you make decisions. And then with reasonable considerable degree of care, skill, and diligence. And I always remember this one guy using this example to say that if the company it is in a financial position and this director now decides that he's going to buy himself this new red Ferrari, but he can't pay the expenses, that's not acting in good faith, and it's not in the company's best interest. So it's looking at things like that, and King 4 is a very nice guideline for directors to say, how do I do these things? What does acting in good faith look like? And Tasneem, that can be something that you guys can maybe also touch base on at a later stage in some of your webinars. And then looking at disqualified directors is if somebody is legally disabled, if they are unrehabilitated insolvent, and if they have been removed from office on account of misconduct. This also includes dishonesty. So if there's any legal steps that was taken against a person, and that can also be anybody that was convicted of theft, fraud, forgery, there's a whole list of things that will disqualify you of becoming a director on a company. I don't think we always ask these things up front.
No.
Great. So on shareholding, it's important to know that CIPC does not actually keep record of shareholders. It's the responsibility of the directors and the company to keep the records of the shareholding. So that's why we issue those share certificates. And I'll quickly show you on the next slide what a share certificate actually looks like and what needs to be indicated on there. So a share certificate is therefore only issued by the company itself and cannot be obtained from CIPC. So if you lose your share certificate, there's a process that we usually go through that we'll say we will recreate the history and we will take it from the start and we'll recreate it for you. But then there's certain declarations that you need to do in order to get that in place. And then also indicated on the company's MOI would be an indication of the initial authorized shares capital. So that would say maybe your company was registered with 1,000 shares or 100 shares, and that will indicate your authorized share capital. That would mean you've got up to 100 shares that you can issue in that lifetime of the company. It doesn't mean that you need to authorize all of them at the same time or issue all of them at the same time. You can have that partially done, but if the 100 is used up, that's kind of it. And then only by means of a special resolution, you can increase that at a later stage. And I'll show you the difference between the two shortly.
So yeah, and also because I remember when I started my digital marketing company like 5-6 years ago, and when I did obviously with a PTY Limited, you also have to have shares in a direct and all of that. And then it was like, then they asked on the form there about the shares, and I was like, I don't know how many shares I'm supposed to have. And then I remember the accountant said, just put 100. And then I was like, okay, 100.
Exactly. So I'll show you how that works shortly. But your MOI will basically indicate the classes of shares. So you can get different classes of shares that's got different rights attached to them. It will tell you how many shares per class there is, and also if there's any rights or limitation to the shares. So what will usually happen with different classes of shares is you will get, say, a class A share, and they will have rights to voting, they will have rights to dividends, they will have right to change the MOI. And then you can always have a different class of shares which say you will only receive dividends. So that's why it's important to know what is stipulated in your MOI. Then shareholders may also may have directors of the company, and the director's choice whether they want the shareholders of the company or not. And then also the minimum directors required on the company would be 1. So I think I touched base on this article that I found last time as well, just to give you a little bit of a background on how the changes on shareholding has actually come into effect with the new Companies Act as well. So then also to ensure that you endorse your share certificates if the transfers are restricted. So this is a very interesting concept, restriction of shares. So that would mean that if there's some other reason why the shares cannot be transferred, or maybe a requirement that needs to be met before the shares are transferred, you need to ensure that that is stipulated on your share certificate itself. So usually, if you look at your share certificate in the bottom left hand corner, there would be special conditions. So maybe you get into an agreement with somebody and they will offer you 500,000 Rand in terms of investment in your company, and you are not allowed to transfer your shares until that money has been paid off. Then they can actually have that as a stipulation on the share certificate. I know usually some of these big organizations actually require the share certificates to be printed with that stipulation to make sure that you can't just transfer the shares. And then also the rights of the shareholders to receive notice and access to information as stipulated by the MOI. So they can have access to the company's records, the financials, different things that needs to happen there. Once again, that will also come in with the PAIA manuals that's set up for companies and organizations. That is the public access to information. So there's certain information that you as a shareholder or a director can automatically ask access to. Then, as I mentioned to you, I wanted to talk a little bit about transfer of shares. So what will happen is that you can actually change the structure of your shares in a company. And you can do that by adding or removing a shareholder in the company. So you can do that in two different ways. You can either transfer shares or you can issue shares. So it's very important for you to understand the difference between the two. So what I've done is I've given you the breakdown of that. So transferring of shares means that you are changing the existing proportion of the shares between the shareholders. So that could be maybe Tasneem and myself are shareholders in a company. She's got 50% and I've got 50%. And now we decide, okay, fine, for every year that I'm part of the company, I get 2% from her. Then she can transfer 2% of her shares over to me, which means I will have a new percentage. So that is basically where she's transferring some of her shares to me, and I am then either paying her that, and the money then goes to Tasneem directly. But if you want to raise capital in a company and the money needs to go to the company directly, that is where we then issue, or sometimes people talk about allotment of shares. That is where we might have 100 shares that's issued between the two of us, and we now want to bring in a third shareholder. And then we will say, okay, fine, for your 100 shares that you want to have, you have to pay us 1 million Rand. And then we issue share certificate number 3 to them, which means that the money that that person is now paying is going to the company, not to me or Tasneem, but to the company directly. And that's basically the difference between transferring shares from your own capacity or allotting or issuing shares in the name of the company, so that the money then goes to the company directly. I hope that's clear to you.
Yeah.
Great. So this is basically what a share certificate looks like. So I will also send the slides through to you guys if you want to. But basically, it will indicate the share certificate number on the left top corner. So that here you can see it's share certificate number 1. And you can see on the right-hand side, it tells you how many shares is currently issued to this person. Then in the middle, you can see I've put ABC Pty Limited. So that would be the name of the company, and then also the registration number. So this is how we would usually just make sure that it's the right company, because the name and the registration number will correlate with each other. Then it will indicate that I am the shareholder of the company, and then my address details. And below that, it will actually show you the amount of shares written out that I currently have in this organization. You will also see that it says fully paid shares of R0, which means it's no par value shares. And then it will also indicate the sections that says distinctive numbers to say 001 to 100, indicating 100 shares. It tells you where it was signed, the date of the allotment, and then usually one of the directors will then sign there where it says director. If there's more than one director of the company, then both of them can sign. And really interesting enough, the shareholder doesn't even sign this document. It's signed by the directors of the company.
So how does a share certificate, is this something you just create, or how do you create a share certificate like this?
Correct. So we've got a program that we use that will create the share certificates. At one stage, I know that you could actually buy this from Waltons and CNA, and then you could physically write it in. But I think it's obviously a little bit more professional if you've got a printed one like this.
Oh, okay.
Yeah. So there's no requirements in terms of what it should look like. Must it be on blue paper or marble paper or anything like that? But it's got more to do with the fact that the information needs to be stipulated on this document and it needs to be correct.
Okay.
Great. Then the next form that I want to show you is called a transfer deed. So under the old Companies Act, we called it a CM42. But under the new Companies Act, we are actually using transfer deeds. So this would happen that in the case that it's the shares are being transferred from one person to another, this is captured on this document. So what will basically happen is that, say for instance, I was share certificate shareholder number 1, and I'm now transferring my shares as a whole to Tasneem. Then my details will appear at the top saying that I'm canceling share certificate number 1, and then that will then go over to Tasneem, and she will now become the shareholder of the 100 shares, and she will then have share certificate number 2. So they are in consecutive order. So number 1 is being cancelled. You've got the transfer deed that is then signed by the previous shareholder and the new shareholder to say that I accept it and I'm saying I'm releasing it. And then you've got a document called a minutes of a meeting or resolution that will also confirm that the shares are being transferred. So that's just something interesting to know, that it's not just the share certificates that's important, but also this document to say that it's being transferred from one person to another and both parties actually agree to the transfer.
So would that be like in the case of, say, I'm the director and 100% shareholder in my practice, and then I immigrate and now I'm going to sell my practice?
Yes.
Not only will we have to change the directorship, we also have to change the shares and then also do a transfer deed to transfer the shares over to the new director.
That's absolutely correct. So this is part of the basic documentation that you need in order to say that Tasneem is no longer going to be the shareholder of the company. Somebody else will now be the shareholder of the company.
Okay.
And then right at the bottom, you will see there's an open little section there that says revenue stamps. So in the olden days, we really had to spoeg and plug there to actually have the real revenue stamps on there, but they are now doing this through SARS e-filing. So you will then log on to SARS e-filing and you will then make a payment onto your SARS e-filing account for the stamp duty. And then we literally just put the reference there to say that the stamp duty was paid. So the stamp duty is usually if you pay 40,000 Rand and above, because the calculation that is then made is to say that the stamp duty on that shares is 100 Rand. So anything that's less than 100 Rand in terms of stamp duty is exempt, but anything above 40,000 Rands consideration value will only amount to 100, and then you will have to go to SARS e-filing. But we'll help you with the calculation, don't worry. Great. And then, yeah, we said we wanted to speak a little bit about partnerships. So I think this is something that has come up quite a bit over the last few days. Just saying that now you're going to be this incorporated company, but what about the PTY Limited? Is there a way that we can work around it? And this is kind of the idea.
Before we go into that, I just wanted to also ask with the director and the shareholders. I
Yes.
seem to remember somewhere in the Health Professions Council document something about directors, but I can't remember now what is the ruling around in with health practices. Can you be must you be a director to be a shareholder, or can you issue shares to employees, for example? And then isn't there a rule or something that you can't be a shareholder in a private practice if you are not sort of involved in the practice? So like a private company, like I can't now go and buy shares in my friend's private practice. I'm not sure if I misunderstood that or if I didn't read it properly somewhere. I'm not sure if you know what that rule is.
Okay, now that's totally a legit question. So that is where it comes in with the incorporated company and the MRI. So an incorporated
Okay.
company would usually stipulate that whoever has been appointed as directors of the company should have the same qualification.
Okay.
So that is why everybody that's going to be in an occupational therapy capacity all need to be occupational therapists.
Yes. But that is as directors. So, but my question is, so as directors, you obviously have shares in the company, but can shares be issued to non-directors? So, can you give your employees shares?
No, because
And
in
okay,
this case, the shareholders and the directors are the same people and they're taking the liability. So
okay,
that
okay,
article that I sent on the slides earlier, they said that there might be a slight difference in who can be shareholders and directors, but it's more a case of not all the directors need to be shareholders, but that doesn't mean that you can necessarily bring in a family trust or somebody else in
yes,
as a
okay.
shareholder.
So not all directors need to be shareholders, but all shareholders must be directors.
Yeah, or the requirement at least to say that you've got the same
Okay.
qualification as such. Yeah,
And then
you
also
can't.
because I know I'm not okay. Maybe this is something we can address next time around franchising, because I know that they also have some rule in there where they say that you can't be in, or they call the word itinerant or something practice if you are not in that like physically there. So I can't have a practice here in Four Ways and then a practice in Sandton, and I'm only in my practice in Four Ways, and I've got other people working in the Sandton, and I never go and practice there. They said that that's not allowed. So I'm not sure if that then changes if you have multiple directors. Then does it not matter then? Because as long as one of the directors is in each of the practices, I don't know how that works. Like, and how is it that people can have multiple location or franchise practices if that is the rule that is stipulated?
I think that would be really interesting to read the requirements of that. So I think we can definitely touch base and maybe get back to the organizations in terms of that. I think the main thing would be is it's about the liability, because if you're not giving if you're not seeing the client and you giving an opinion on that, how
Hmm.
legit is that?
Yeah.
So you're getting somebody that's not qualified to actually do your work for you, and now something goes wrong. Who are they going to hold responsible? And I think probably it might be that
Yeah.
if
Okay.
you have more than one practice, as long as you feed the client for that work there, you might still have a practice that's selling supplements or something else, that they can sell while you're not there. But when it comes to the consulting, I think that's where the important part is, that you are the person that's giving that, and not somebody
Okay.
else doing the consulting work. But let's find out, and we can definitely get somebody in that's maybe a specialist on that, just to give you some insight in terms of that.
Okay. Great. Yeah.
And that's actually linking up with this quite nicely, to say maybe you can decide you are a few professionals to get together, but in some way you want to cover some of the cost. Then you can set up something like the studio that could be a PTY limited that can then obviously have some of the assets of the building, or maybe a combined reception, a telephone system, and things like that. But
so
then
anything anything that doesn't fall under the scope of our Professions Council can fall under the PTY Limited.
Correct, yes. So I had an interesting discussion today with one of the ladies that I tried to get hold of last week already, Alta. And then she actually said to me that I kind of put the scenario in front of her, and I said to her, I've got this client, they've got a PTY limited, they obviously need to be an incorporated. So what do I do now? Do I convert the PTY to an incorporated company, or do I keep the PTY limited for ad hoc purposes and maybe register a separate incorporated company for the practice? And she kind of guided me in that sense to say that it might be good to have something like the studio where you can have supplements or some expenses, and then have your incorporated company for your requirements with your consultation and your legal liability there.
Okay. And that's kind of how you can then have a multidisciplinary practice. It's just that each discipline will have their own their own invoicing, because you have to, as a physiotherapist, invoice on a physiotherapy invoice. You can't have OT physio and speech all on one invoice.
Definitely. So some of the things that I wanted to discuss with you guys in terms of partnerships is just some of the things that could be an advantage, and some of the things that you just need to look out for when going into a partnership like this. So it's usually an organizational structure. There needs to be some or other agreement set up, and you need to indicate who's going to be the owners of that organization. The reason for that being is that it's good to have that companionship, and you've got some mutual support. I mean, if you 3 or 4 professionals and you can just bounce off each other a little bit, that's always good. And you can obviously then have some of the resources and some of the expenses that you can share. But once again, depending on how big is the area that you're going to take up, how small is the area of that the other person, are you going to be there 5 days a week and I'm only going to be there once a week? How do you set that up? So it's really important to kind of get into that detail to say how do we split the expenses and how is that going to be operated. The agreements need to be identify the responsibilities, the joint rights, as well as the obligations. So if something happens at the premises, whose responsibility is it? How are we going to take that further? It obviously also gives you the access to knowledge, skills, and experience. Obviously, through the guys that's around you, you might gain some knowledge how they are operating or how they do their invoicing or whatever it might be. And it's like having this soundboard of people around you just to say, but how do I make this? How would you feed this client in lockdown if they don't have the money to pay? Things like that you can maybe just have a discussion about. Once again, important to have lines of communication. If decisions are being made, are we sending it via WhatsApp? Do we have a group? Do we send it via email? Who's informing the landlord of a water pipe that broke? Anything like that might happen. And then also an inclusive approach to say, let's work together, let's plan together, and how are we going to implement it? Maybe we want to make it nice, and we have to put a little bit into the kitty just to do a nice painting or something like that. Those are type of things that you can include in a partnership, and it's not all your expenses. But things that you have to remember is that a partnership is not as such a legal status unless you're going to maybe use a PTY limited where you are all joined. So a partnership can just be an agreement. So just deciding on how you're going to structure that. And then also, if it's only an agreement and not a formal company, some people will perceive that as not being professional. So they will ask, but why don't you have a registered business? How do I know that you're legit? So these are some of the things that people will, from the perception, just come and say, but but we're a partnership, but you're not registered. So what's going on there? Once again, also looking at unlimited liability. If something goes wrong, if somebody slips somewhere, who's taking the responsibility for that? And also taxation. So that's why I said I think it would be a good idea if we can get a tax specialist in that can maybe talk us through what is best between a sole proprietor, a company, and incorporated, and where do we put what in terms of our assets? Do we buy the property in the PTY Limited where we can have certain expenses and it's a going concern at a later stage, and we just bring in new shareholders as new people come in? I think that might be a very good discussion. And then also the potential conflict of separation. What if things don't work out anymore and you've put everything into this partnership, or you've put in 100,000 Rand to make the place nice because you guys all have this beautiful vision of this place, and now something happens and you want to step away. I mean, you can't just take your 100,000 out of that again and say, it's not my worries anymore. So it's really important to have those agreements set up to say, how does this work, and who will take responsibility for what?
Yeah, so I'm actually glad you brought this up around partnership versus PTY Limited, and in having separate inks under that. So I think that's just something to emphasize. So a partnership is kind of like a sole proprietor, except that there's a multiple individuals together. So it's like a marriage kind of. So like a marriage, if you have to go through a divorce, it gets quite messy because all your assets are entangled and all of those things, right? So even if you have and so kind of having this agreement that you spoke about, agreement and ownership put in place, a partnership agreement, that is kind of like having a prenuptial agreement when you get married, right? Whereas the other scenario is that you have the PTY limit. So the difference there would be that each person in the Inc. can be also a director in the PTY Limited. Is that correct?
Yes.
So that would be...
That should be fine.
Yeah. So myself and three of my other friends, we each have our own practice. I have an OT practice. The one has a physio, the other one has a speech therapy practice. We each have our own Inc. But we are also each directors in the PTY Limited. Is that correct? So that kind of makes it not like a marriage. That's kind of just we're all renting a house together. And so if one person needs to move, somebody else can move in there. Because the way I understand it is is that with a sole proprietorship and a partnership, because it's got the similar kind of legal structure, the difficulty is that you are your practice. So it's not as easy to swap someone out. Whereas in a PTY Limited or an Inc., you can easily swap a director out because the director is just a person in the practice. The practice is an entity on its own. Is that kind of, am I understanding correctly?
Absolutely. It's like, say, for instance, you need to rent a machine for doing your print work and things like that. Now you're doing it in a sole proprietor. So now if that sole proprietor is not there anymore, then you need to sign a new contract for having the same print in the same place. But whereas if it's a PTY Limited, then you're basically just keeping the contract in the name of the PTY Limited, but you're changing the direction from one person to another person, and you just inform the organization. And I think that's sometimes the difference between having it formalized and having a official company or something like that to run through. Whereas with a partnership or maybe the sole prop, you kind of have to go through that whole thing again. And do you really want to do that? So once again, depending on where you are in the size of your business and where you want to grow, that might be something to consider, starting off with a sole prop, but knowing about these things to say, as soon as I'm getting somebody else involved, let me look at a better structure or a different structure. And especially when it comes to assets and things like that, when it starts, I won't say becoming complicated. I mean, it's part of business, but at the end, you kind of want to get to that point where you say, I want to be professional and I want a legacy to kind of be left behind. So I've got this incorporated company that I'm going to do my practice in, but I've got this PTY Limited that's now selling some products or some whatever it might be, and that is an ongoing concern without you having to be there the whole time to be the representative of the organization.
But that's also why I think I can't stress enough why it's important to have an accountant involved. And I know, like, as sole props, it's like they think of it as an additional expense. But you don't necessarily have to have an accountant that you pay every month to do your books. If you're happy to do your own books, you can most accountants, you can find an accounting firm that will maybe 3 times a year, like, so every quarter they will just go sit with you. And also to find an accountant that you're going to build a relationship with, not just somebody who's going to do your book, somebody that will sit with you and talk through what your goals, and then actually has also knowledge on tax, and that they can understand, so that they can advise you and say, look, based on your books now would be a good time to now think about incorporating, and then talk you through that process and what the tax implications are and so on. Because it's not necessarily something that you're going to notice, you in your practice working, and you see the money come in and out and so on. You're not going to necessarily be checking, oh, can I change this month? Can I change that month? Somebody needs to maybe just like alert you, look here, you are over the tax threshold or something like that. Yeah.
Absolutely. And it's small things like being aware of when you need to be registered for VAT or not registered for VAT. So maybe there is and that's why I said maybe with some of our next discussions we can have that, to say that maybe you can split the business slightly and say it's still keeping me under a certain threshold, so I don't need to get VAT registered, but at this stage I need to be, because this is the size of my practice. So I really think that there's a lot of scope for you guys to go into the detail of something like that. So I made the suggestion to say maybe next time we can talk a little bit about shareholders agreements and contracts. What do you need to look out for when you sign a contract or go into a contract with somebody else? Things like tax implications on the structures. When is it Pty limited one? When a sole prop, when a Inc. And then also, I think we touched on that last time as well, a little bit about what happens if I want to close down the business or wind it up. So what will happen? And I think that's really very nice and very practical ways that we can talk about these. Okay, let's just know what's lying ahead so that we can say, okay, fine, let's get our ducks in a row just to have everything in place.
Yeah, and I think also on that last point of winding down or closing down a company, it's also if you are wanting to sell your practice, or conversely, if you are looking to buy an incorporated practice, what are the kinds of things you need to look out for to make sure that the practice you are buying is compliant, and what are the kind of things the red flags kind of you need to be aware of in case this person hasn't been running the practice correctly, and you inherit like all these like terrible things, and you have to pay all these things that's outstanding that maybe you aren't aware of because it doesn't reflect in the books. So like maybe they have COID that they haven't paid. I mean, I know with my business I had to pay I don't know what happened where I wasn't receiving the COID invoices or something like that, and then suddenly I was hit with the 6,000 rand bill. And luckily my accountant now arranged that it gets paid off, and so they split it up. But something like that, it won't appear in the books, and now you're happy with how this is a profitable company, and then you buy it, and then suddenly you have like 10,000 rands worth of bills that you must pay that you didn't account for. So yeah, those are kinds of things we don't really know about when we.
Absolutely. And it's also the question of, are you taking over an existing business, or can you maybe take over the business but still have your own business, your own company registered, so that you don't take over all the liability, you're just taking over the practice. And those are the type of discussions that I think is really important as well.
Yeah, I never even thought of that. That's a good point.
Great. But yeah, that's me for today. So thank you so much. Really great. And please send through the questions. It's nice to talk to you guys through this. I mean, these are actual things that we sit on with a daily basis. So thank you.
So before you go, I just wanted to ask you something around your services, because when it comes to the memorandum of incorporation, like although you explained it so nicely, it still feels like overwhelming because if it's a lot of business speak. So is that a kind of service that you also assist with, drawing up a memorandum of incorporation?
Yes, absolutely. So we've got a very basic one that we use for the registration of the incorporated companies. But if a client wants to have it very comprehensive with a lot of details, we've got an attorney that can then work with them on that. With most of the
Okay,
guys,
excellent.
they're smaller practices, so it doesn't need to be so intricate. But I think once it becomes like, say, for instance, um, five directors and five shareholders, you really want to get into the details, and then the attorney
Yeah.
will definitely help them with that.
And then also with the share certificate you mentioned, you've got, is that also something you can assist with when you need to do the deed of transfer, all of those kind of things? So basically all the things you mentioned that are requirements, if somebody needs help, so the company partners is basically like a all-in-one service related to matters of registration and compliance and all of that. So yeah,
Absolutely.
okay.
We want to do that one-stop shop. So you just call my cell phone number, or I actually put the toll-free number for you down today, and you can
Okay.
contact company partners, and we can definitely help you further.
Excellent. Thank you so much, Ilana.
Thanks, Tasneem. Thanks, guys.
Bye-bye.
Bye.